Welcome, everyone. Thank you for joining us tonight. My name is Joy Robinson. I am one of the adult services librarians at Piscataway Public Library, and we are very pleased to welcome Kenneth Vercammen, local Edison attorney and author of the ABA's Wills and, I'm sorry, I lost my page. Sorry, Ken.
Wills and Estates book for the American Bar Association.
Yeah, I beg your pardon. So the way that this evening is going to go, we are going to have Mr. Vercammen present, and then he will answer some questions. People thankfully posted some advanced questions when you registered, so he will answer some of those questions. And then we will also have a guest this evening, a financial planner from New York Life Securities, Dan Fabrizio, who will answer questions about financial planning and mistakes one should avoid while doing that, especially in light of COVID-19. Okay. Thank you, Ken. Welcome.
Okay. Thank you, Joy. Thank you, Piscataway Library. Well, it's been a weird past year because we used to be in front of crowds of people, and now we're talking into screens. But on the other hand, no one has to drive in the rain, drive in the snow. But there's been many changes that we didn't anticipate a year and a half ago. But one thing's remained the same. I'd say bad things happen when you do no planning. Bad things happen when you don't have a valid will, a valid power of attorney, a valid living will. So, for example, sometimes people say, why do I need to have a will? I'm married. Doesn't everything go to my spouse? He goes, well, maybe not, but that's not doing planning. That's like not having life insurance when you're young and have kids because you don't plan on dying. Things happen. So, for example, if someone does not have a will, or the will was not found to be valid because it was improperly prepared or improperly signed and thus not admissible to probate, the process to distribute assets becomes much, much more complicated. So if there's no will, it would require all the children to select and agree upon someone in the family to be an administrator. Then all the children would have to sign a renunciation affidavit in front of a notary. If all the children don't sign a renunciation affidavit in front of the notary and have it filed for a fee with the surrogate, then a complaint order to show cause will have to be filed in the Superior Court. The cost is over $3,000. Well, the cost of doing a will, if someone's looking at $400, $500, that's certainly less than $3,000 and less aggravation. Number two, if there's no will or the will isn't done right, then the person who becomes the administrator has to take up what's called an insurance bond or surety bond. So another additional $1,000 or whatever fee, and there's additional legal cost. Three, if someone doesn't do these things ahead of time, state law determines who gets the assets, not you. And more people are saying, listen, do I have to provide equally, or can I instead, distribute as I do? And it goes, yeah, it's your right. So during the program, more people are saying, listen, I'm going to give it to my grandkids rather than my own kids. Why should my son, Dr. Brendan, the dentist, have a bigger boat? I'd rather have it go down the road to grandkids. Or sometimes you got kids that don't spend time with their parents or grandparents. So you want to be able to have the document done and determine who's going to get your assets. If someone has minor children, think about, hey, if something happened to both parents, who would you trust to raise kids? Who don't you want? Because sometimes the easier thing is, who don't you want to be the guardian for kids? And instead, if there's no will, a stranger in New Brunswick, the judge determines that, and you reduce the opportunity to cut down on expenses. But most importantly, by not doing proper planning, I'd say you're creating problems and aggravation amongst the family, usually fights, lawsuits, etc. So when loved ones are grieving, dealing with the passing of a family member, they shouldn't be overwhelmed with financial concerns, estate problems, etc. So believe it or not, one of the things that COVID did, it made everything easier to have the documents done, because prior to this, we used to require everyone to come into our office by appointment, during business hours between, 10 o'clock and 4 o'clock, take a pen and write out everything in their own handwriting. And now, back last January, goes, you know what? Let's start doing something new. Let's start doing something better. Let's email the questionnaire. This way, people can fill everything out at their home. They can save it as a Word document, not a PDF. They can email it to us. And without people even coming in, I can then call everyone up and say, okay, here's what I suggest based upon your facts and circumstances. And, and New Jersey, by the way, did away with the New Jersey estate tax. So, people are saying, what? You didn't list my assets in the will. He goes, I don't need to know your assets, really, because let's say, unless you have more than $11.7 million, there is no estate tax. That's the amount for federal. So not too many people I know have more than $11.7 million. And for people that come from, I'll call it the, regular family, together, I said, do you want to disinherit your wife? They usually say no. Do you want to disinherit any of your kids? No. Do you want to disinherit any of your grandkids? No. Okay. I know what people need, sometimes better than what they have, because I've been doing this for a living for 35 years. And when I needed knee surgery years ago, I didn't ask the doctor a lot of questions on, how exactly it was happening. I goes, doctor, you've done this before, and, do you think it'll be successful? So, what else has changed with COVID? Well, again, people can pay online through, credit card, PayPal for their attorneys. And probably the easier thing is that what happened last March and April, the whole state closed down, except for the UPS stores. So people were able to go to the UPS stores on the weekends after 5 o'clock and get their documents signed with a spouse and another friend as a witness, and they didn't have to, drive to the attorney's office and take half a day off of work, or coming from the city. So it was made easier. But part of what we also say to people is it's still a call to action, because what was also happening is, like, people are saying, listen, I need to get a will or, power of attorney for mom, dad, or Uncle Joe because they're in a hospital. I goes, well, by this time, it's typically too late. And what happened, even now, a lot of the nursing homes, a lot of the hospitals, no one can come in. They're closed to the public. So the whole idea is getting your things done now, and having things done right. I mean, if someone knows they're going on vacation, you don't decide on a Friday where you're going to go and how much you're going to spend. You plan ahead of time. So we've tried to make, and so let's now talk about things that will go into the will. Well, the attorney sends someone a questionnaire, and basically someone types in their name, the spouse's name, who's going to be executor one, who's going to be executor number two. We never recommend joint executors. I'd say there's a reason why there's not two captains of the ship and two steering wheels. There should be one person as number one as number two. I've seen a lot of problems where people have joints, and even if they could be identical twins living together, best of friends, but you're creating twice as much work, because that means that two people have to sign the the paperwork for the surrogate. Two people have to sign a listing for the realtor to sell the house. Two people have to sign the contract for the sale. Two people have to sign the addendum to the contract. Two people have to sign every single check, every single document. Why create more work? On the other hand, we've had cases where there's two people that they couldn't agree upon what color the sky was. Brother number one says the sky's blue, and the other one says, no, it's gray. You're stupid. You've always been stupid. They're yelling at each other in court and fighting over couches. So the better thing to do is there's an executor one, and an executor 2. And keep in mind, who should be the executor? Well, it should be someone that can, kind of do the job and get, when COVID's over, we can get around, that our rule of thumb is, can they drive to the surrogate's office? Can they park on the 3rd floor or the 4th floor, take the elevator, then walk up the hill and go to the surrogate's office? Let's see, because the idea is, if someone can't drive, if someone can't walk up a flight of steps, well, it should be someone that is more mobile. I'm not anti-senior, I'm not anti-disabled person, but we have to be practical. We want to try to make it as easy as possible. And if someone is 89 years old and they're partly blind and can't drive, they're not the best choice to be the executor of the will. Now, we do most of the things remote, but I always talk to everyone. Again, I call everyone from the car. I call everyone from, the office. And, we do ask a few questions in the interview form. Do you own any real estate? Where is it at? Approximate value. Then we ask, questions. Okay, other assets, ballpark, approximately how much? Don't need to know account numbers, don't need to know details, because the real thing is, assets are not listed in the will unless someone knows the exact day they're going to die and what they're going to own on that day. Now, there are certain assets, though, that don't pass under the will. So examples of that are, if a house is owned husband and wife, say, well, that's called tenants by the entirety, automatically goes to the surviving spouse. Sometimes houses are owned joint tenancy. Sometimes people in a relationship but not married own it joint tenancy. It goes to the survivor. Sometimes a child and a parent may buy a house where it's going to go to survivor. So a will doesn't change that. Bank accounts that are POD, payable upon death, right of survivorship, those automatically go to the survivor. The will cannot change that. Now, there's certain assets that pass by way of contract. And examples of that are IRA, 401k, life insurance, annuity, a pension vehicle, anything that has a direct beneficiary. The will cannot change that. So I typically recommend that when people are doing their estate planning, that they get a printout that specifically sets forth who is the beneficiary of that account, and then they put it in the folder with their will documents after they sign it. This way, you're making life as easy as possible for the executor, especially if the executor is not someone who lives with you. And why seeing the beneficiary in writing is important? Well, let's see, never assume. I was married for a decade, and I found out one of my life insurance policies still had my dad. 10 years. I assumed everything was changed over. We missed one. Well, now I know my dad would have done the right thing, but why create more work? So now, typically, when you're doing your planning with the attorney, you're setting forth, hey, who's going to get your stuff? But keep in mind, if that person passes, who would get that person's share? Let's see. And more, I mentioned, people are not, leaving it outright to everyone equally. They don't have to, because some kids or grandkids need it more than others. Some people are saying, listen, I'd rather put it towards, my grandkids' education, so they can go to a better school, as opposed to leaving it to one of my own kids that would just buy luxury items and wouldn't use it on getting the grandkids the best education. On the other hand, sometimes people, someone recently asked me, do I have to treat all my kids equally? And I goes, no, that's your right. You decide. It's your right. You're right. You don't have to leave anyone anything. What do you have in mind? And she goes, well, one of my kids, we don't hear from much, lives on the West Coast. So I said, well, I'll ask you a question. Christmas, did you get a card or a call? She goes, no. On your birthday, did you get a card or a call? No. On Mother's Day, did you get a card or a call? No. Well, why should you leave that person anything? On the other hand, sometimes we set up trusts within wills so that you could have a child that is they have like issues. They could have substance abuse issues, financial issues, and we just don't want to have them plucked with getting $200,000. I handled a litigation case in Somerset County, and the lady had set up a trust. And the monies for one of the kids was to be used for that person's support, but so that the person had, the apartment was paid for, car insurance was paid for, because the person had alcohol problems. And there was a motion by his ex-wife to invade the trust to compel it to pay over for alimony, etc. But the judge agreed with me. The reason why we set up sometimes these spendthrift trusts within the will is so that it's protected from taxes and from ex-spouses and from creditors, etc. Because hey, if you give an alcoholic $100, they'll buy $100 worth of booze. You give someone $2,000, they'll spend $100 on booze and give away the rest. So the whole idea is to try to make it as easy as possible. Now, sometimes people don't have any children. He goes, well, you're the more important people that should have it, because who don't you want to get it? And who do you think could benefit best by, someone's money? And, people sometimes say, you know what, let's see, I'd like to give some money towards like, my church, towards my charity. I left money towards my college's cross-country team. University of Scranton. I left money towards the St. Thomas Bishop Art track team, because they not a huge amount, but something towards St. Francis Grammar School's track program. So the idea is that you can put these kind of things in the will. So specific amounts are called specific bequests. Let's say, but there has to be in writing. So on Mother's Day, someone could be recorded saying, hey, I want all my jewelry to go to my granddaughter. But not only does the executor not have to follow that, the executor is not allowed to follow that, because the executor has to follow what's in the four corners of the will. Some ladies sometimes say, listen, I want the jewelry to go to my daughter, my granddaughter, because they know that if their son's the executor, he'll bring it to Cash for Gold and say, what do you give me for this junk? I've had men who have, they have hunting rifles or, things like that. And they give it towards someone that has a firearms permit, or they might have their baseball card collection or coin collection. And it makes them feel good that they left their baseball cards to someone. Now that person could leave it to, have things that people think are valuable are not. Collectibles are only collectibles when you spend the money for them to collect them yourself. All right. Now, we've mentioned specific bequests. Sometimes people have the reverse specific bequest, meaning I leave nothing to and name a person. And, again, it's someone's call, what they want to do. We don't leave them $1. We don't say a reason why. But if the person passes, they do need to be, anyone who would inherit under the will, without the will, it just have to be served a written notice of probate. But that's part of our probate thing. Right now we're talking about wills. Now, you do want a clause to protect minors, let's say, or protect 24-year-olds, because listen, we all know when we were 23 years old, and if we would have got a big chunk of money, would we have invested it wisely? No. The age of majority in New Jersey is 19, and I'm pretty sure no 19-year-old invests money wisely. So typically when someone has minors, we have a clause that says they get some money when they're 22, some money when they're 25, the balance when they're 30, but the executor trustee can distribute as much money as is needed for that person's support, maintenance, care, etc. But that's important, because otherwise, if there's not there, they get the money when they turn 18. And not only do 18-year-olds not spend money wisely, but they get influenced by what we call the other. So, if someone was going to be inheriting money when they turn 18, if it's a dude, the girls would be their new friend and try to get the guy to buy them nice jewelry. For the girls, their boyfriend would say, oh, you should rent a house down at Seaside for the summer. You have money, this, et cetera. So the idea is the monies that we have worked so hard for, we don't want to give it to a kid or a grandkid that's just going to run off and blow it on stupid stuff, or be threatened to give over money. Because listen, what do 19-year-olds do? They try to get someone to buy them beer and go down to Seaside. Now, if someone has minor children, there's a clause that says who's going to be the trustee. Think of the trustee as the person who holds the money. The guardian is the one who holds the children. So I ask my clients, sometimes they can't decide right away. He goes, okay, who do you trust to watch your kids for the next 2 weeks? And then I ask them, who don't you want? Well, there's not really that many choices. And no, it's a tough call, but no, it's not a tough call. Now, I'd say they're used old wills. I'd say used to have to find the witnesses. So there was a law called the self-proving will statute. So under the old method, the person signed, 2 witnesses signed, but then typically you'd have to locate one of the 2 witnesses to sign an affidavit or go to the surrogate's office to say, yes, that's my signature and I witnessed the person sign. Well, I remember in one case, they said they wouldn't sign it unless they got $500 out of the family. $500 for signing a piece of paper. So the new statute is self-proving. That's where someone signs, the 2 witnesses sign, the attorney or notary signs, and then we have the self-proving attestation, affidavit clause to indicate person signs again, the 2 witnesses sign again, the attorney or notary signs again. That way the witnesses don't have to be located after the fact. And the good thing in a way is that it saves the people money. And I'm pretty sure that old documents that were done years ago don't have that. I know that, these cheap things that people try to find online are not usually self-proving. They don't comply with the Uniform Probate Code. And then the people think they're saving money, but it's costing them more in the long run. What else do we, and typically the interview form asks, hey, what questions do you have? I'd say, sometimes people ask me, what if I move? Well, your will done in New Jersey is valid in any other state. I'd say, how often do I need to change my will? I'd say a will that's done now is still good in 30 years. But the question different is good, or does it still contain what you want? But if you have an older will, look to see, is the person who you picked as your executor still able to do the job? My grandfather was a smart guy. But when he was 95 years old, he didn't run up the 5 flights of steps to go to the 5th floor of his place in the Bronx. But he was the executor of his cousin's will because it was never updated. Now, logistically, due to COVID, what we do is we email out a Word document of the will, power of attorney, living will to everyone with instructions on how to sign. And the reason why we send people a Word document is after they receive it, sometimes they say, you know what, I want to switch around who these 2 people are. He goes, okay, no problem, you can do that. But I told people, do not change the legal part of it, because then you're screwing it up. I mean, if you have medical issues, don't try to do your own surgery, and don't try to do your own electrical work. Let a professional do that. So in the will, clauses are: number 1, debts and taxes paid. 2, distribution to spouse. And sometimes we have a trust set up for a spouse. It's very common in second marriage situations, but sometimes with older people, instead of leaving the money outright to them, if money is left to the spouse in the will in a spousal trust, then that is protected from Medicaid. It's protected from creditors. Distribution to children or grandchildren. Sometimes there's a trust within the will. Let's say you're putting down who's executor 1, who's executor 2, a clause that says no bond required. And after the documents are signed, then I recommend that the people, now, only the original will can be admitted to probate. Let's say a photocopy of the will cannot be admitted to probate by the surrogate. Think of the surrogate as a fancy name for the will clerk. Let's say they need the original will, an original death certificate. They need their surrogate information sheet filled out, and a check for maybe $150. Let's see, no original will, then there has to be a formal complaint, order show cause, and everyone that would have inherited if there's no will has to be served, and then there has to be a hearing in front of a judge. So, now, why do people sometimes scan their wills? Well, the only reason they scan the wills is so that they can forward it to their kids and say, this is what we signed, and this is who the executor is, and if you have any problems, come to me. Don't bother your brother down the road. All right. But the important thing is, I tell everyone, if you don't know where your original will is, get a new one done. Say, again, a rule of thumb is that if you can't find it in 40 hours, don't cheap out. Go get the new one done. Now, let's now touch upon trusts. Separate trust, revocable trust, living trust, etc. That's it. Periodically, people will ask us, my mother-in-law used to always say, I want to come in and get a trust done. And I said, were you watching Susie Orman? And she said, oh, yes. I go, Susie Orman is exactly right, having these revocable trusts done. If you live in New York, California, Florida, probate, difficult states. New Jersey is the probate easiest state in the country. So when someone says they want to have a trust, it goes, why do you think you need to have a trust done? Some people says, I want to avoid probate. Well, probate costs $150. Let's say they say to save taxes. A living trust doesn't save taxes. It's not. The living trust salesperson says, it's a private document and doesn't have to be admitted to probate. But listen, unless someone's leaving the money to the Ku Klux Klan or Crazy Club, what do you care if everyone knows who's getting your stuff? It's usually no big secret who's getting your stuff. I'd say, but they're one of the few benefits of the trust was the people that had trusts when the surrogate's office closed to the public and nothing was being probated for weeks and weeks and weeks last spring. If there's a trust that can be, as soon as someone dies, hey, you're good to go. Now there's a different, but a living trust is revocable. It does not protect any money from creditors. It doesn't protect it from Medicaid because you have the control. There is a thing that's called the irrevocable trust. So that's common for in cases of people want to protect their assets in the event they have to go to a nursing home. But so that means that the assets are no longer owned by you; they're owned by the trust. You're not the primary trustee. Someone else got to be the trustee. You can't close the trust. And so a lot of times there's pros and cons, but I do tell people that, listen, having trust done, they're usually spending like $3-4 grand a piece, and they're retitling assets. And the other thing is that if there's a mortgage, you want to get permission from the mortgage company, because the mortgage always has a clause that says you can't transfer ownership to another entity without their approval. So that's a little bit on living trust. Yeah, they avoid probate, and someone has to explain to me why they want. Now, if someone has a condo in Florida, he goes, definitely put that condo into a trust in the state of Florida. That's for someone's benefit. Okay, so after you sign your what we also typically, as mentioned, we email out the documents. We tell everyone, print them out and read them. Don't read them on your iPad. Don't read them on your iPhone, because you don't read them thoroughly. Print them out and make sure it contains what you want. We do a self-proving will. We include a clause that says no bond is required, and that way it's as accurate as possible. Now, and by the way, I always tell anyone that attends any of our programs, if you attend our program, we typically charge a $200 consult fee. But if they attend our program, we wait and they come and see it. They contact us within 30 days. We don't charge the $200 consult fee. Okay. The next document we're going to talk about is a power of attorney. Your will takes care of your assets in the event that you die. What a power of attorney is, it's a document where you're giving the power to spouse, family member, or someone you trust to make sure that if you became incapacitated or disabled, that your bills can be paid and that they can act on your behalf legally. And for a lot of people, the power of attorney is more important than the will. Let's say, just because someone's married, it doesn't give the spouse the power to transfer assets and sell a house. And the important thing is, we often get calls on a Friday afternoon. I need to get power of attorney over mom, dad, or Uncle Joe. He goes, well, unfortunately, you can't get power over anyone. Let's see. They have to affirmatively give it to you. They have to say, yes, this is what I want. I want to give power of attorney to someone else, and they have to be physically capable of talking and signing. If they can't do that, then there's no power of attorney, and someone has to go through an expensive and complicated guardianship proceeding. And again, who wants to have to go through this complicated and expensive guardianship proceeding? Guardianship proceedings are very sad, expensive, and lengthy. So, in the power of attorney, you're giving the power to someone to make sure that your bills are paid, that your assets are, kind of protected, because you're giving the power to someone you trust. Now, the power of attorney is either effective right away or only upon disability. If it's effective right away, that's called a durable power of attorney, and it stays in effect durable even if someone becomes incapacitated. Effective only upon disability. Most people don't pick that, but it's only effective if someone becomes disabled within the statutory definition of disability. Now, we had a client, he says, Ken, you're using legal jargon on me. He goes, I'm a carpenter. Please explain to me in carpenter language, not springing and durable and etc. He goes, okay, that's it. Joe, that's easy. Okay. Let's say if your power of attorney is effective right away, your son can steal all your assets right away. If it's effective only upon disability, your son has to get a note from a doctor before stealing your assets. Knowing that, do you trust your son? He goes, oh, I trust my son with my life. I goes, well, good. Then make it effective right away. That's what most people do, because if it's effective only upon disability, then you got to go and prove, get a note from a doctor, and then you got to go and prove to a bank that the person, the note is good, that the person is disabled, and that they're not dead. So we recommend that it be effective right away. Now, after the power of attorney is signed, you need a witness who is not the agent, not the spouse, and it's signed in front of the attorney or notary plus the other witness. I do recommend that document be scanned, and then you want to forward it to yourself, agent 1, agent 2, your kids if you deem that appropriate. Plus, you want to forward it to your financial advisors. You want to forward it to your bank, any place you have money, your accountant. Therefore, they have it on their record. So in the event that it has to be acted upon, then again, it's already in clear writing what you wanted. And part of doing planning is planning to make things as easy as possible. Because here is something also that is important. Let's say some of the banks used to give people a hard time, and they'd say, oh, it wasn't done on our Wells Fargo form, so we need to have it done on our Wells Fargo form or whatever bank. And so eventually the New Jersey legislature came up with a law to say, listen, if it makes reference to New Jersey statute, and the bank does business in New Jersey, the bank has to honor it. But it has to make reference to the New Jersey statute, section 2 of PL 1991, C 95, C 46:2B-11. And I'm pretty sure the cheap things or free things you find online aren't going to say that. So again, let's say have it done right, so that therefore it's valid. Now, let's see, I mentioned a will is valid now, it's valid 10 years from now, 20 years from now, 30 years from now. And no surrogate can say, well, it's old. However, I do recommend people re-sign a new power of attorney every 5 years. This way you avoid the issue of a bank giving you a hard time, or a financial institution. I do recommend if someone moves, or your agent moves, the kid or spouse, you've picked, if they move, have a new one signed, because the problem is, someone has their daughter as their agent, then the person breaks their leg. They go to the bank. The bank goes, who are you? I'm Joe, Skuznik's daughter. He goes, well, you're a different person. The person on this document has a different name and a different address. And the person goes, well, I got divorced, or I got married, and I'm living here now. And the banks typically say, no. We're not going to honor it. So the idea is, you do the documents and you put it, with your, served copies of your professional. The last legal document I'm going to talk about is the Living Will Advance Directive, Durable Power of Attorney for Healthcare. So think of the Terry Schiavo case, the Karen Ann Quinlan case. Someone's in a coma, irreversible condition, they're in a hospital. Well, this document is not really for you, so your family doesn't have to go through the trauma of having to make that call. Let's say, because it's where you can't talk. So the idea is that, say you're giving instructions to hospitals and doctors that if there's no coming back, there's no getting out of the bed, no opening eyes again, what you would want. And I remember one time a doctor where someone did not have a living will asking me what should be done? Should we pull the plug? And I remember saying to Dr. Cheese, doctor, I feel bad. I mean, you know what the right decision is for someone who's 92 years old that's never going to open their eyes again or walk the planet, but the idea is that you feel bad saying yes in that person's life today. That's why you want to have the living will, so that the decision's already made, and you can just say, doctor, this is what they picked, and respect their wishes. So in the Living Will Advance Directive, let's say we took language from the actual medical society's format. Therefore, doctors can be familiar with it. But the good thing is that, so they talk about fluids and nutrition, feeding tubes, etc. Let's say, to be withheld if someone's in a coma or provided. Now, some people got scared away, saying, "Are you telling me that if I had a heart attack, that they wouldn't revive me or do anything and just leave me on the floor of ShopRite?" He goes, "No, they're good. The hospitals and the paramedics will do what is appropriate for someone brought into the emergency room. But we're talking about down the road, someone's on their last stages of a terminal illness, or they have a stroke and they're in a coma and there's no coming back and they're brain dead. Well, okay, you're giving those instructions. So fluids and nutrition is provided withheld. Then there's the next section dealing with artificial, and probably 85% of the people nowadays say, listen, there's no hope for me. Let's end it all. Okay. All right. Now, the next section, the Living Will Advance Directive, life-sustaining, medical treatment machines, and 99% of people say, no, don't do any. I don't want, pull the plug. Let's see. I used to say years ago, if I can't run every day, I want to be put down like they do to racehorses. And then the first time I was on crutches and I couldn't run, he goes, wait, I don't want to be put down yet. Keep me around. Okay. So and now there's a section also that says organ donation yes or organ donation no. And I always recommend, listen, if you're gone and you can help someone, then say yes. Something interesting is I went to a seminar by the NJ Sharing Network, and they're the official organ donor entity in New Jersey. I said, what's the maximum age to be an organ donor? And they said there is no maximum age. I goes, well, what's good on an 85-year-old guy? And they go, skin and corn. It goes, wow, I never thought about that. If I was burned in a fire, I'd rather have old guy skin than what got burned off me. Okay, real fast. We're going to talk now about probate. Now, probate in New Jersey, let's see, it used to be I would tell someone, okay, someone came into my office, like so-and-so died. I goes, okay, do you have the original will and a death? Yes. I goes, leave my office now, drive to Middlesex County Surrogate. It's 7 miles from here, and you'll be back in 45 minutes. Someone's in Monmouth County. He goes, okay, go to Freehold Surrogate. That's 19 miles from here. Come back in an hour. And they'd be back in an hour. But the surrogate's offices, for the most part, are closed to the public. So we have to fill out forms. We have to forward them to the surrogate's office with a copy of the will, copy of the death certificate, the form filled out, and then they email. Some surrogate's offices email to us, others mail to us. Then we have to sign all these different forms, in front of the clients, and then we got to forward to the surrogate the original will, death certificate, check for $150. All these signed, notarized forms that we have, we send it by certified mail because we can't even drive to the surrogate's office and put it in a drop box outside because they say close to the public, close to the public. Now, there's a handful of questions that I'm going to touch upon real fast, and then I'm going to have my financial planner, colleague, come in. So just bear with me because I'm trying to do as much tech stuff as possible. Okay, so number one, can a doctor serve as a medical proxy? No, the doctor cannot. Attorneys don't. It's usually a family member or someone you trust. Let's see. There's only been rare times where I have even been an executor where someone says, Kenny, listen, I'm 89 years old. My wife is 80. It's going to charities. We trust you. Okay, fine. I'll do it then. Let's see. Who do you give your completed documents to? Everyone. Let's say someone mentioned a gifted deed. The problem with just gifting things away is that if there's a falling out between the two, then they can kick you out. Sometimes that's a rare instance where rather than just gifting it outright, maybe you want to put it into a trust where they're getting it, but it's there. A will that was done in 1995 is still valid, but you got to look, okay, do you still want those people as executors, or are your kids growing up from 1995? Is a notarized letter stating bequest given to children okay? No, because that can't be admitted to probate by the surrogate, and that sometimes causes fights. Let's say IRA retirement accounts. Who's ever listed, that's who gets it. Now, currently, there's a step up in basis for certain assets if someone dies. Let's say someone bought a house in 1990. They bought it for $30,000, and now it's worth $430,000. Well, if someone dies, there's a step up in basis, so the family doesn't have to pay capital gains. However, if you just transfer it to them, they get the carryover basis. So we're waiting to see what the new president's going to do with that. Someone mentioned, let's say if someone's divorced, their spouse is written out of the will, but it's still important to get new documents done because there's old documents that you've given the power to a spouse to do stuff, and you really trust that spouse can walk into a bank and illegally withdraw your money. Probably not. So I mentioned if someone's name changes, if they move, get a new power of attorney, new living will. Can a lawyer serve as the power of attorney? We don't do that because it should be a family member. The process. What's the process on starting a will? I mentioned that we email out the will questionnaire to people, and we don't need to know a lot about someone's assets because they are typically, leaving it to the people that they like. I'd say quick claim deeds to minors, don't do it. I was in probate court one time, and it wasn't my case, but someone had signed over their house to one of their kids. The daughter was living with her, and then she gets remarried. The new husband's in the house, and the new husband finally says to his wife, "Hey, you got to get rid of your mom. She's driving me crazy. She's a kook." And so the daughter goes, "Okay, mom, you got to get out. But this is my house." "Not anymore." And the judge said, "Listen, this is a horrible case, but the law is the law. The gift was made." Someone mentioned, should I still have a will even if our bank accounts have survivor beneficiaries? Yes, because there's always assets that someone has that does not have a direct beneficiary. And also someone should always have a power of attorney, because a will is only of assets after you pass away. Other quick questions. I've discussed estate planning. Doing an LLC. An LLC does not protect as well as someone thinks it is, because let's say if someone owned a house, rental house, and it's owned by the LLC. Yeah, if someone got hurt, the LLC protects you from liability, but probably still going to be a defendant, because they're going to say you did the repairs negligently. So, we typically recommend, someone owns like investment properties, have good insurance. Computer software, I tell people, don't cheap out. Don't do your own electrical work. Don't think you can watch a YouTube video. People used to change their own oil and cars. Someone it's like someone says, "I'm not going to go to a doctor. I don't want to pay the deductible. I'm going to go to WebMD and figure out what I have." Let's say, having wills done, the attorney is going to charge you, $400 or $500 each. It is very good investment to have things done. Now, if someone gets when someone's getting married for a second time, they'll call me up and goes, "I want to get a new document done." I goes, "Listen, why don't you hold off and see how things pan out?" "Oh, we've been together for 3 or 4 years." He goes, "Well, listen, if you want to put them on some of your accounts, go do that. But let's listen. Again, I always say I love making money, but let's wait and see how this marriage things pans out. We don't want to have 20-year-olds get money." Okay, so that is like I've touched upon wills, powers of attorney, living wills, a little bit about the surrogate's office. We don't have a lot of time to cover everything on the planet. So, I always tell people, hey, down the road, let's say, speak to, consult with a professional to have things done right. And with that, what I'm going to do now is ask that the library now bring in Dan Fabrizio to talk about some of the common financial planning mistakes that he's seen through COVID.
Good evening. Joy, is there any more questions for Ken, or are we good to go?
Well, there's a few more in the chat. Did you want to answer a few more?
Let Dan start his presentation now. Okay.
Okay. All right, and maybe there'll be time after. Okay. Yeah. So let me just welcome Dan Fabrizio from. Am I saying your last name right, Dan? Is it Fabrizio or Fabrizio?
Fabrizio, it's fine.
Okay.
Any version.
Oh, like Fabrice. All right, that's how I'll. Okay. Dan Fabrizio of New York Life Securities, who is going to talk to us about financial planning and mistakes to avoid post-COVID, or as we're not quite post-COVID, in the aftermath of COVID. Okay. Dan, I'm going to try and spotlight you so that we can, where are you? I don't see you.
I already did, Joy. We're good.
All right, great. Thank you.
Good evening, everyone. My name's Dan Fabrizio. I'm a registered rep, obviously, with New York Life Securities. My background, I worked on Wall Street for 22 years, where the institutional investors were my clients. And I think now I work on Main Street, where individuals like yourselves are my clients. And I'm licensed in both the states of New Jersey and Pennsylvania. And I just wanted to touch on some of the common financial planning mistakes as you get near retirement or into retirement. And there's like several I want to touch base on. I'm not going to get into too much detail, but just give a high level, explain it from a high level. Number one, not planning your retirement with your life expectancy in mind. Stop using your parents and your grandparents as estimates for your life expectancy. The reality is life expectancies are increasing more than they were 30 years ago. The important part, I feel, is to rely on data, not a hunch. But be careful not to be fooled by actuary estimates. There's nothing deterministic about life expectancies estimates. Number two, not being smart about claiming Social Security. Some people are still taking Social Security well before full retirement age. This means if you apply for Social Security before your full retirement age, you will receive a smaller monthly Social Security check for the rest of your life. If you have the financial resources and believe that you will live longer than average, generally speaking, waiting to take Social Security at a later age means you'll receive a larger check, depending on your financial situation. So if you want to learn more about that, the Social Security website actually explains it quite nicely. Number three, taking a lump sum from a pension could lead to expensive mistakes. But thanks to annuities, it can help retirees meet their retirement goals with the guaranteed lifetime income stream when a lump sum payment is your only option. If you're able to receive a lifetime income stream from your current pension, it may be the preferable option depending on one's particular circumstances. Number four, too much risk in your investments as one nears retirement. By taking too much risk with your portfolio, you may not need to dampen or reduce the retirement income that you'll need to live on. So be careful as you get near retirement. You want to be more conservative. If you have 10, 15, 20 years, you can be a little bit more aggressive with the portfolios. Number five, buying life insurance as an employee benefit. And this is probably one of the closer points that has a direct impact on COVID when it comes to life insurance. And I'll explain a little bit more shortly. While it's generally less expensive and easy to take group life insurance coverage with your employer while you're still a worker, this coverage typically goes away once you leave the company and retire. And if you are 50 years and older when you retire, it can get expensive to begin buying life insurance at that age. One option, and the easy as well as too late option, is to buy permanent whole life insurance when you're younger, in addition to the inexpensive employee group term life insurance benefit. But if you're 50 and older, there are still some whole life insurance products out there. Depending on your coverage goals one is seeking, it can still help you with your retirement plans. Number six, focusing on assets over income. One mistake I've seen is failing to switch your mindset from retirement savings to retirement spending when nearing or at the age of retirement. A main purpose of saving for retirement is so that you have enough money to spend in retirement. So say you have $500,000 in your IRA, and in terms of living standards, what exactly does that mean? And based on your spending needs and other income sources, how should your assets be allocated once you retire? Can you safely withdraw 3%, 4%, 5% a year and have it last your lifetime? Here's the reality. It's hard to know what kind of standard of living one can have if your assets are all in one type of product or account. Consider reviewing your situation with a financial professional that can help you with your retirement goals and plans. And number seven, bank CDs. Older adults tend to retire with large sums of money in the bank, and they put them in bank CDs because the bank recommended it. The downside of a bank CD is that you lock up your money into a multi-year CD, and at the end of every year, the bank will send you a 1099 form for the interest that you've earned, and you have to pay taxes on that interest, but you don't get to spend that interest. A better option available, and if you're going to lock up your money for a few years, is a multi-year annuity instead. And here's why. One, you'll probably get a higher interest rate. And two, the most important feature of this is that the interest you earn on an annuity is tax deferred. This means at the end of year one, you will not receive a 1099 and pay taxes on the interest you've earned and cannot withdraw. You would only pay taxes when you take the money out of the annuity once it expires, or if you roll it over into another annuity, it remains tax deferred. And another option with annuities, they now have liquidity aspects where you can actually take money out of the annuity once a year, up to 10% of the balance without any penalty, something you can't do with CD. And the only other option item I just wanted to touch base on briefly, because someone mentioned pre-conference about an inherited IRA. The Secure Act of 2019 kind of changed the dynamics around inheriting an IRA from somebody. Basically, there used to be a stretch IRA. If you inherited an IRA prior to 1999, you were able to keep it as an IRA till you were already retired. So if you received it at age 40 and you have 20 more years, then back then, prior to 2019, you were able to let that ride. But now with the Secure Act, you actually have to, if you inherited an IRA, you have to liquidate it within 10 years. But there's a couple exceptions. The spouses, disabled individuals, minor children of the beneficiaries, and beneficiaries who are 10 years younger than the person that decided. Those are the only exceptions on that. Other than that, that's really all I really wanted to touch base on. I don't know if anyone has any questions out there.
There are a couple questions in the chat, and also a request that you increase your volume a little bit. So one of the questions.
Am I back on?
Can I ask the question on audio?
No,
we
please,
got to do it through chat.
Please do not.
Okay.
Okay.
Okay, so let me go through some of the ones that are in like the chat. Okay, let's see. Sometimes someone says like, well, will the bank be my executor? Will they be the trustee? Well, most banks will not do it unless someone has a good amount of money, and they're only going to do it if they can make money, because like there's laws that limit what trustees can get, what executors can get, etc. So I tell people, well, you can ask around, try to find someone that can do it. Now, interestingly, as far as being the executor, if it's not a human being, you want to pick an entity, you got to ask them ahead of time, make sure they're willing to do it. I have had clients that they were gonna leave most of their assets to a particular charity, and they were going to let the executive director of the charity or the person that was dealing with bequest of the charity as the executor, and the charity said, no, we won't be the executive. We don't want, I said to him, well, they're not going to make you the beneficiary. You just want the money and you're not going to do anything to get it. He goes, yes, we won't be the beneficiary. So, ask ahead of time. Next question. Can the executor live out of state? Yes. They don't even have to go into the surrogate's offices now. We fill out the papers, it's signed in front of a notary, then we forward it in. We've had executors that don't live in the United States of America. Let's say my client goes, listen, I don't, I came here from India. I came here from the Philippines. Aside from my spouse, we don't have anyone here. Got to be someone in India. He goes, yeah. If you have no one else, I'm sure you can trust your brother better than someone that you might have met at work that isn't going to be at that job, and your friend in 2 years. Let's say, yeah. Now, monies that someone inherits. The next question talks about keeping assets in the family and not going to in-laws. Let's see, monies that someone inherits is not subject to equitable distribution if someone gets divorced. Let's say, yeah, but if that person dies, then it's whoever would inherit if they have a will, it goes to that person. So, sometimes someone says that's a reason for having a trust, to say, listen, I'm going to have, I don't want it to go to my kid, because if my kid dies, some of it would go to his wife. He goes, you're correct. That's a reason sometimes for spending the money having a trust. Now, for married people, there's two wills. One for one person, one for the other person. There's no such thing as a joint will. Someone says, I have a joint will. He goes, well, then you probably did some garbage online, but there's no such thing as a joint will. Next, there's a question on tax consequences if someone is the beneficiary of annuity. The financial advisor is going to have to answer that question, because I tell people I do the law end as a professional, but for a lot of the income tax questions, I said that's something to be answered by other professionals. Typically, people recently asked me some questions on taxes, and I said, do you have a CPA? Yes. Better ask them, because they're doing taxes every day. I'm doing estate planning, I'm doing the wills, I'm doing the probate, but the tax laws change all the time, and I don't do my own personal income taxes. I have a professional that does that. Mr. Fabrizio, do you know the answer to the annuity question?
Yes. Can you hear me okay?
I can hear you.
Yes.
Okay. The tax consequence if you are a beneficiary of annuity. The tax consequences would be the beneficiary's tax rate. There is the basis of the annuity, right? Whatever money was put into the annuity, that's not taxed. You're taxed on the gain. So if someone put in $25,000 and it increased only $10,000, when you inherit that annuity, or the beneficiary of the annuity, and withdrawals from that, portion of the payments to you will be part basis and part gain, and you will be taxed at your particular tax rate on the gain part of the annuity. I also see a question on who guarantees an annuity. The annuities are not guaranteed by the FDIC or the bank or the SI SIPC. The annuity is guaranteed by the financial strength of the insurance company, which is why it's very important to understand the annuity you're buying it from, that you totally understand the ratings and the financial strength of that insurance company. Look at their histories. For example, look at AIG during the financial crisis of 2008. They almost went belly up, and they had to take billions of dollars in government handout. That particular year, New York Life made a $2 billion profit to insurance companies, but comparatively, New York Life has been around for 175 years. They made profits 165 years out of 175 years in existence. And they're AAA plus rated by Barron's and all the other rating agencies. But understanding, a second and third tier level of an insurance company, you really need to dive deep down and look into their financial strength.
Okay, and with that, I think we are done for tonight. Are there, Joy, do you have any questions you want to pose to us?
So I know I'm going to get this question. So when can you come back?
Let's see. We'll do this again at some point in time. But before I forget, my name is Ken Vercammen, and I'm an attorney in Edison, New Jersey. My office phone number is 732-572-0500. For those people that don't have the internet and Google, and I also say, please call after 10 o'clock, because 9 o'clock is crazy time to call when everyone's walking in, etc. And again, we're trying to make things as easy as possible. I mean, I went through a transition last January where I was having everyone come in, and then I was sitting somewhere and doing documents out of state. And I goes, wait a minute, this is the easier, better way. And my client says, yes, this is the easier, better way, because I don't have to make an appointment and come in. So again, Ken Vercammen in Edison, 732-572-050. Ironically, this is the Piscataway Library. Across from where my law office is on Woodbridge Avenue in Edison is what's called the old Piscataway Town School. Edison had one of their original schools that was called the Piscataway Town School. Why? I don't know. It's currently used as a yeshiva for young men. But and with that, I think we're good for tonight. Thank you again, Piscataway Library. Thank you, Joy. Thank you, Dan Fabrizio. And let's see. Oh, real fast, Mr. Fabrizio, what's your contact information if someone wants to call you?
They can reach me at my cell, my home office, obviously now since COVID, 609-213-3950 is my direct line. Be more than happy to ask any questions or help anybody out as needed.
Thank you, everyone. And I am on our website, njlaws.com. I'm going to post some updated material. So thank you again, Joy. Have a great evening. Thank you.
Thank you. Thank you, everyone, for joining us. This recording will be posted after it is properly edited. We'll post it to our YouTube channel. So, and we will send out that link to everyone who registered. Thank you very much.
Okay.
Thank you, Kenneth Vercammen. Thank you, Dan Fabrizio.
Be well.
Everyone be safe.
Okay,
Take
bye-bye.
care.
Bye-bye.
Be well. Okay, bye-bye.